Welcome to what is today, December 4th, edition of the Cannabis Licensing Advisory Board for the City of Boulder. Do we have a quorum?
We do.
All right. So in that case, I'm trying to pull up the agenda here. Do you want to go ahead and read the instructions for virtual meeting and rules of decorum?
Yes, thank you. Good afternoon. The city has engaged with community members to co-create a vision for productive, meaningful, and inclusive civic conversation. This vision supports physical and emotional safety for community members, staff, and board and commission members, as well as democracy for people of all ages, identities, lived experiences, and political perspectives. More about this vision and the project's community engagement process can be found at the link here. The following are examples of rules of decorum found in the Boulder Revised Code and other guidelines that support this vision. These will be upheld during the meeting. All remarks and testimony shall be limited to matters related to city business. No participant shall make threats or use other forms of intimidation against any person. Obscenity, racial epithets, and other speech and behavior that disrupts or otherwise impedes the ability to conduct the meeting are prohibited. Participants are required to sign up to speak using the name they are commonly known by, and individuals must display their whole name before being allowed to speak online. Currently, only audio testimony is permitted online.
All right, you ready for a member roll call?
Certainly. Member Christie. Member Daniel.
Present.
Member Green.
Present.
Vice Chair Keegan.
Present.
Chair Kunzman.
Present.
Member Noble.
Present.
Ex officio Member Thompson.
Present.
Ex officio Member Bailey. Chair Kunzman, we have a quorum.
Did you guys get anything from Allison that I don't think I remember seeing? Did we get something? Okay, so she might be joining us too. Let's look at the minutes from the last meeting, which was September 11th, or yes, wasn't that? That's the last set of meeting minutes we have to look at.
That would be October 6th, 2023.
I guess I'm looking at, okay, I'm looking at the October meeting. Yeah. All right, so any comments about or corrections? Motion to approve.
Brian motions to approve.
I'll second it.
Stacy second. And you want a hand vote, I'm assuming? Kristen?
That's fine.
Okay, all approving? Any opposed or abstaining? All right. So I'm still trying to find the most recent. I've got too many emails.
I can call the next item if you would like.
I'm assuming it's general public comments.
No, not for this meeting.
All right. All
The
right.
next item,
I did think we switched it, yes.
yes, is the approval of the Cannabis Licensing and Advisory Board Retreat Meeting Summary from November 6th, 2023.
Any corrections or comments? All right, motion to approve also.
Brian motions to approve the November minutes.
I'll second.
Robin second. Is there any reason we can't do just ask for any opposed or abstaining? Do we need a hand vote? I'm not sure. Andy, what's the ruling?
If you wanted to just do all in favor and then do a verbal vote aye, all opposed, all abstaining, you can use that short form vote that we discussed briefly if you wanted to, Tom.
Yeah, that's what I thought. Okay, all approved? Say aye. Or raise your
Aye.
hand, whichever.
Aye.
And is there any opposed or abstaining? Okay, passes. Found it now, finally. All right. Next item is, this is general public comments. Do we have anybody even in the room that's not affiliated?
We do not.
Okay. We've lost our popularity, huh? Darn. Okay, and then matters from the cannabis and she's not here either though, huh?
Mm.
Do we have any email from her?
So I don't have an email from her. However, she did include a brief summary, activity summary in the packet.
All right, well, I'm trying to find how brief, I'm trying to remember, it was pretty short. Is it short enough that
Yes.
we could put it up on the share screen?
I could do that, certainly. One moment.
If anybody has any questions, I'm not sure who the questions are going to go to other than we'll record the questions, but. These numbers look pretty standard. Is there anything on page 20?
No, page 20 is the divider for agenda item number 4.
Okay, good. Any questions from any or comments or concerns by anybody? Okay, thank you, Kristen. And is it still true that there are no policy suggestion forms received?
Yes, for agenda item number 4, policy suggestion forms received for the December meeting. We did not receive any forms filed timely for this meeting cycle.
Okay, all right, then I think we're ready to go on to Andy. Matters from the city attorney.
Yeah, and thanks, thanks, Tom. I would like to just share real quick our script. So as the members maybe may recall, we had a second presentation teed up for the retreat that we'll go through tonight. It's a little bit, it has some quotations that are a little denser, but I figured we would include them anyway, just to give you sort of an understanding of what the BRC says and some of the language in the code that I'll be looking at. Even if you don't memorize it, you obviously don't need to memorize any of it. I just thought that would be a good point of reference. But before we get to that, we did prepare, as you may recall as well, a hearing procedures script. And so that's part of the packet, but I'm going to share my screen. Hopefully you can see this okay. I'll zoom in a little bit. So this is the draft script that we started with, we used the BLA script as sort of a starting point, and then we really tried to focus on the process and how can we make this as quick as possible while still checking all of the boxes that we need to check. And so you can see here, and it's in your packet as well, that I've highlighted in blue sort of the different sections just to flag them visually for you all. But basically all of the quotation is either the chair or the vice chair, whoever's presiding over the hearing. So most of the members, you probably don't need to know much of this. There is some licensing clerk portions where Kristen will chime in, but the key points are that when we start a new application, we're starting the record. So we record everything, so everything's part of the record for purposes of our video recording. But any reviewing judge would need to know exactly where things are starting and ending with the particular applicant and our particular application reviews. So call to order, we just name the basics of the business, and then interested parties. So the licensing division is automatically considered an interested party as well as the applicant, but it's an opportunity to announce whether there's any other persons that have been expressed an interest to be considered, a quote unquote interested party within the meaning of the Boulder Revised Code. So we'll walk through and see if there's anybody else that has or is claiming to be an interested party. And then the meat of the script is this introduction section. A lot of box checking, but it's basically setting up the hearing. We have this license, we're recording the proceedings, we're going to have an opportunity for public comment. And then the conflict section, which is probably the section the members you all need to be most concerned about, is and I'd prefer to hit on this in advance with you, but basically, do you have any conflicts or potential conflicts? And for purposes of this, we're really looking at either a direct pecuniary interest, i.e. a direct financial interest, or something that you think would so color your view that you couldn't decide the matter objectively. So it's hard for me to know what all those conflicts might be, but it could be that you are close friends with the principal member of the LLC that's applying for a license, or it could be that maybe you've had discussions, somebody contacted with you about the particular application and concerns. It could be, I'm trying to think of some of the other common ones that we could potentially see. The point being is it's best to disclose it all, regardless of whether you think you need to be recused or whether it's just prudent to disclose it. It's always best to just be public and transparent about any potential conflicts, and then just to leave that to me to decide whether it merits recusal, or on occasion we could designate you as a non-voting member, for instance, where you can participate in discussions but not vote. If it's the type of conflict that requires recusal, what we'll ask you to do is to mute yourself and turn off your camera so that you're not in any way involved with the review. But most conflicts, unless it rises to like a clear conflict, you're going to participate. And I say that right now, principally because you all are part of this community. You all are involved in some way, shape, or form with the cannabis industry. And I think it's a pretty small world, and you're going to know people, and people are going to know you. And, you know, if we go digging for conflicts enough, we're going to end up subverting the intent of the BRC and the city council, which was to have a representative board. And we don't want to do that. And we don't want to inadvertently dismiss, board members or encourage people to try to seek out conflicts to get board members withdrawn from board presentation. So that's kind of a long-winded way of saying, try to come discuss any potential conflicts with Riwa and I before the meeting so that we can assess them. But just know that, it's truly designed to nip personal financial conflicts in the bud, and not as a means to unnecessarily disqualify board members who could otherwise decide the matter objectively. So with that portion, are there any questions or thoughts on the conflicts before I move on, members? So we'll continue. So attorneys, we'll get into this with the presentation in a moment, but these
And
here,
let me
sorry, yeah.
let me check in on the conflicts thing, and I'm just going to choose some hypotheticals because I don't have any good ones that I can say. Let's say someone was, an LLC was going to go in front of us, and I'm just totally making this up, that my daughter always, they have another business, and my daughter always buys from them. Is that a conflict?
No, I don't think so. No. We're really looking at, like, you're a member of the LLC or you have a contract with the LLC that's going to bring you business. Those types of things are really what we're focused on. And the reason why we're focused on that is because there is a portion of the Colorado revised statutes that, at least at the state level, and there's case law that's come out of this that specifically says, look, if you have a direct pecuniary interest, you're conflicted out and you need to be recused from making decisions, right? So you can't be using your board position for personal financial gain. And there could be maybe more attenuated instances where you have some personal financial gain that you'll realize that will probably require recusal at that point as well. But, we have to be careful to accomplish the overall objectives of what it means to have a conflict while not sort of kicking ourselves in the rear end and not being able to conduct business, for example, because we don't have a quorum. I've had boards where the board had such a stringent conflict policy that we would end up having almost like never ending indecisiveness because we could never get a quorum on different matters. And we ended up with that board loosening our conflicts policy specifically so that we could carry on business. So yeah.
So it's pretty easy when, if I owned a business or if a family member was a part owner in the business.
Right.
But I guess the reason why I'm even bringing it up is if somebody even could be perceived as having a conflict of interest, it'd probably be wise to bring it to you or Riwa.
Yeah,
before.
yeah. That's our preference, is think about it broadly to bring it to us, and even disclosing it publicly. Like, you can disclose anything. I mean, if it makes you uncomfortable and you want to disclose it, I'd encourage you to disclose it publicly, not just to Riwa and I, but in the board meeting. And I think that's a good point too, Tom, that you just mentioned. Like, if it's a family member, like especially an immediate family member, that'll probably require a recusal. If you have a family member that's in the business that's applying, and I can't think of any other instances right now I've run into, but those are the key pieces. So, and I'll add this too. One of the ways that we'll address conflicts when they arise, if it's something that's suspect, is to just address it with the parties appearing before the board. So, you know, do you object to this person continuing with the decision? No. Do you object? And just addressing it at that point. You know, if somebody objects, that's not dispositive of the issue. We're still going to have to make some sort of independent decision on that. But if people don't object, then it's not an issue. So.
Okay, but I just want to reiterate what I heard you say, is that if one thinks they might have a conflict, then you obviously would bring it up publicly, but you might have the option of bringing it up with you or Riwa before the meeting just to talk it over.
Yeah, it's always best. I mean, bring it to Riwa and I's attention before the meetings. We'll probably want to have a call or at least just email with you about it to understand the conflict and the scope of the conflict, and you know, make a recommendation as to what you should do at the board meeting in terms of like, I mean, hopefully we can get to the point where you'll understand it's a conflict and we'll have discussed it and you're just going to recuse yourself. Or if not, you can explain on the record why not. So.
Okay. Oh, and by the way, Allison did text me and said she's sorry that she's not going to be able to make it today. She said she was going to send an email also.
Okay. So chipping through the rest of this, the attorneys, as I was mentioning, I mean, I don't know how often that will arise where people will arrive with attorneys. My guess is, and Kristen Chingaris and I have discussed this a little bit, but most of your hearings are probably going to be, if they've gotten to the point where they're coming for approval, you know, they're going to know what staff's position is with respect to whether they've met all the requirements. And that doesn't alleviate your all's obligation to go through and verify those requirements are met, but it does mean that in all likelihood, there's going to be cases where it's clear cut, you know, they're entitled to a license and they won't have lawyered up. It's not going to be contentious. It's going to be just a matter of going through the process that the BRC requires, right? So there's those instances, but then there could be instances where things are contentious for whatever reason. Maybe there's a dispute where they know staff are very much against a particular license for whatever reason. Some requirement or multiple requirements are not met, and they've lawyered up and their lawyers appear to represent them and speak on their behalf. And that's obviously within their right. So, you know, but we want to recognize those attorneys and their role and just verify that they're speaking on behalf of their client, you know, who they represent. And some of those I'll say, you'd like to think that everybody's operating in good faith, but you know, this is the world of government regulation, and I don't know how often licensing has seen this or instances where they've thought they've seen this, but you know, there's times when people know they're probably not compliant and they're going to try to sneak one past the goalie, so to speak, or they're going to really push an issue. Maybe a lot of other applicants have previously understood a particular location, for instance, isn't viable because of whatever factor. And they'll lawyer up and they'll say, well, we don't think this is constitutional, or we don't think that this is, you know, this language is sufficiently defined to where they can apply this to us. Let's push it. Let's go see if we can get a license at a location that maybe, you know, isn't deserving, at least according to staff. And so you might see that. You might see folks come in really prepared with attorneys, knowing there's an issue that the city disagrees with, and they're still going to push it, and they're going to create their record, and they're going to do that for purposes of appeal, probably, you know, or to persuade you all. And that's, you know, something that I would imagine if we do this licensing business long enough, we'll run into at some point. So, and maybe that time will be sooner rather than later. I don't know, but yeah. So the procedure, we just set out the order, which is first taking public comment. So the plan is to allow anybody, regardless of whether they're a party, to come in and give public comment. We're announcing that for the applicant, we're announcing that for staff, we're just putting that out there with the thought being that the public should have an opportunity to express themselves as part of this proceeding. And that's taken just like any other public comment. So your typical 3-minute time period to speak. It doesn't require any sort of response from any of you all. It's just an opportunity for public comment. So next we'll hear staff who will present, and they'll be it goes into the timing here. So then we'll hear testimony, and the parties are obviously the city, the applicant, and if there's any other interested party that's been admitted. We say each presentation that anybody gives will be limited to 10 minutes unless good cause is shown for additional time. So there's an allowance where if you all determine good cause is shown, you can go beyond the 10 minutes. And in essence, what you can think of this as is everybody has an opportunity to present what's called their case in chief. And then as soon as they present, any other interested party can ask them questions. So, in formal court proceeding, you can think of that as cross-examination. For this, hopefully it's not quite as stringent as that, but it's just an opportunity to say, hey, you guys agree with us that this is the case, right? Or you would say this, or it's an opportunity to confront sort of the opposing witnesses, right? So after each party has their 10-minute time to present, then each party is going to have a separate time for rebuttal presentation as well. And then after each party has had time for rebuttal presentation, the board will go into deliberation where you all will debate what was heard. So, again, it could be simple. It could be, staff have these preliminary findings that say they're entitled to a license. We didn't hear anything contrary to that from staff. The applicant agrees, and unless you all got into questioning that maybe created issues, it might be pretty simple. It might be, well, does anybody have any concerns? Does anybody have any objections? If there is none, then you might be ready to move into a vote pretty quickly. But there could end up being, contentious issues or concerns that you legitimately have that you think need discussion, and that's your opportunity. The evidence, quote unquote, the evidence is closed. That's your opportunity to share thoughts, exchange ideas, make sure everybody's seeing things the same way to the extent possible, and hopefully come up with a consensus. But if you can't come up with a consensus, so be it. At least you'll have discussed it and you can take a vote and see where everybody lies, and you'll understand sort of where the differences lie in terms of those viewpoints. So are there any questions or thoughts about that part of it right now? Okay. So, and keep in mind, we're still discussing the procedure as part of this script. So, but we say witnesses, we'll offer up to see if there's any witnesses an interested party has. I don't know who that might be. For the city, that could be Officer Gignac, for instance. But it could be any number of persons that somebody wants to call as a witness to present their personal knowledge or their thoughts on whether an application should be granted and what issues there are. We mentioned at the retreat that you'll have preliminary Yeah. Yep.
So what would the timing be? Like, for instance, when somebody does the application and when it finally gets to us, will they have been visited by Officer Gignac or probably not at that point? Or
Kristen, do you want to jump in? Kristen's a lot more familiar with the process, I think yes, but
So the way that we've set up the process for cannabis licensing is
oh no,
their
right.
inspection would happen after the license
what I
is
thought, yeah.
approved.
Yeah.
But Officer Gignac would have the ability to visit the facility ahead of time if she was inclined to do so, especially if there were any safety or security concerns. It's possible that she would visit it, but the official inspection wouldn't happen until after the license was approved by the board.
Okay, that's what I
Conditionally
expected.
approved.
Yeah, that's what I expected. I just wondered the sequence of events. Only if she had prior knowledge of that location or that owner or that something to do with that application. I got you. Okay.
And that gets at, Tom, what do these witnesses look like? I mean, in reality, there's going to be so much of it that's what's called documentary evidence. I mean, we're going to have the application and whatever materials they submitted with the application. You'll have staff's preliminary findings. And all of that will be information, right? That's all going to be information you'll have received before the hearing beforehand, and you'll probably, hopefully, have had a chance to give it a good look and critical thought and think about any issues that you may have identified or concerns, potentially thought about questions you want to ask the applicant, right? If an applicant is coming in and it doesn't look like they've met an element for a license, hopefully you all will have thought about some of the questions that might get at the heart of the issue. And if I'm being frank, I mean, you want to be as objective as possible, but you want to create a record that if the intent is to deny, you want to have the applicant on record saying, yes, we agree with X, and if they're not agreeing with something you think is factually the case, why not, and you kind of, we're going to go into demeanor a little bit in a little while with the presentation, but I mean, your job as the board is the gatekeeper for these licenses, right? So, you're charged with thinking critically about this, and you don't want to unnecessarily impede people who have a right to a license, but you also want to make sure you have a clear understanding of what the facts are and whether they're entitled to a license. And you should probe into that, make sure people are being honest, and that you're satisfied that a license is warranted. So we'll get into more of that in a moment, but that's kind of a part of this process, is getting all the documentary evidence, reviewing it. That all becomes a part of the record. And if there's witnesses, including the applicant, posing some of those difficult questions if there's something at issue, right? So, so the script leads into, it kind of does an introduction of, do we have any evidence? What are there any other documents aside from the application and the preliminary findings you're going to admit, any party, right? And then we get into the actual sort of verbal part of the hearing. So you'll take public comment, and that's what this part facilitates. You'll take staff testimony to the extent there is any, aside from the preliminary findings. My guess is most of the time it's just going to be, here's your preliminary findings. Those are a part of the record, but you'll have the opportunity to ask questions of staff. The applicant, during their time, they'll present, which is their testimony. And so you'll get to hear from them and ask questions of them. Staff will also have the time to ask questions. There's the rebuttal portion, which is, hopefully at that point, nobody will be surprised by anything that's been said, but at least we're giving each party one last opportunity to make statements that are part of the record and are part of evidence. And then there's the kind of the closing of the evidence. So the formal closing of the proceeding no more evidence is admitted, no more testimony. It's time for the board to, and you'll see this is a motion to kick off the deliberation / debate. So we're closing everybody's participation in the debate except for the board. So everybody's had their chance to speak. Everybody's had their chance to admit evidence. Y'all are done. Like, this is the board's time. Closed record, or at least closed with respect to evidence. And then you'll go through and have your debate. And eventually that'll culminate in your motion, which for a decision, which is just I gave you that motion script that we had, which somebody can read into the record and you can take the vote. And then Tom or Brian or whomever will close it off with thanks everyone. That completes our hearing. So I know this is a lot to take in. So I'm hoping that we can, when we do our practice, that'll give us some practice. But I think more importantly, once you've done a couple of these live, even though it seems kind of complex now, I think it'll get really predictable and everybody will kind of get comfortable with it and will anticipate what happens next. And having a script, I think, is really important just to make sure we're consistent and we're checking these boxes. And this is like, obviously it's a totally public script, so we'll give it to the applicants. Everybody will know what to expect and when. If they want to object to some portion of it, they can. My guess is they won't, because I think it makes sense. But that's kind of the purpose of this. And hopefully at the end of all of this, even if there's a contentious hearing, we'll have a pretty good record where if somebody sues the board, or sues the city rather, that it'll be a record that's clean, organized, and your decision making will be well supported. So are there any thoughts before we kind of close this out, or changes or suggestions or anything?
Thanks, Andy. I think that's really great. Appreciate you going through the details. The only question that comes to mind is, would there be a time when the board is going to have this type of proceeding and then go into our regular conversations, or is that kind of yet to be determined?
Yeah, so this will, well, I don't know if Kristen has thoughts on that, but you mean like in conjunction with like a regular meeting that you would do
The
this?
types of meetings we've had so far, it's really different edition.
Kristen, yeah, go ahead.
Yeah, it's a great question. I think honestly, it kind of depends on if there are other topics that the board wants to make sure to discuss within a given month, then we would likely include a public hearing and those topics on the same agenda. But if there's nothing that's time sensitive and it can wait until the following month, we could also just focus the meeting primarily on the public hearing. So I think we'll have to see how things go once we get to that point and see what's on the board's agenda and what you all would like to include in that particular meeting.
Okay, that makes sense. Thank you.
Sure.
And it's just a question just as a kind of procedure. You sort of had outlined how there might be an applicant who wants to game the system or try to push the envelope as far as possible, and staff will kind of give our board a heads up at a meeting about sort of the contours of some of that potentially. Once we kind of make a decision and close and they decide to appeal or sort of sue or something like that, that doesn't come before our board anymore. There's no like that appeal process is sort of like outside the scope of what our board considers at that stage, right?
Yeah. So the appeal process it'll be to Boulder District Court would be the appeal. And so I think we got into this a little bit in the retreat presentation, but basically the record's compiled. Typically a transcript is made of the entire record and the video transcript's made available to the judge and the parties brief it. And the only way it could come back to you all is if the board reverses. So it's kind of a finicky thing that the courts do. They, it goes back to the whole co-equal branches of government from civics classes, where the judiciary doesn't like to interfere with the functions of the judicial and executive branches. And so what would happen in all likelihood is a board would kick it back to us and either require that we approve the application, and it would still be our decision to approve the application in some sense. Board basically says you're wrong. Or it could be that the board maybe just finds there wasn't sufficient justification for a specific issue, but that there could be, and wants us to reevaluate that. So it could be like a remand in that fashion. Or it could be like an affirmation of the decision. And then in that case, it's up to them to continue appealing it to the Colorado Court of Appeals or to be done. So that's kind of what happens. And in terms of what you'll hear, since it's pending litigation, we won't discuss it at length, but I'll let you know that an appeal was raised and that it's gone to district court for review. And then I'll let you know that decision once it comes down, obviously, win or lose, even if there's no further action needed of you. If we win, I'll let you know. Yeah, that's what happens.
So in a situation where we deny it's appealed, and then the judge upholds the decision or like makes a decision, I guess, saying that this license should have been approved, then it could come back to us. I guess you would have more guidance at that stage about like what we should do, like in light of that decision. But I don't know, it's probably too far down into the sort of what ifs, but.
Yeah, it starts to, there's some weird things that can happen on appeal. And because sometimes parties will raise things that, for instance, so a constitutional argument could get raised that you guys didn't rule on. And the judge will maybe find, yeah, you're right, applicant, this provision is so ambiguous that it's void. I hereby declare it void. I'm going to send it back down to, or the judge might interpret it in some way. Maybe that would be rare, but the judge might interpret a provision differently than we interpreted, and then send it back down to us for a decision in light of the new interpretation. Like, so that kind of thing could happen. In all likelihood, the judge will just say, the most likely case, the judge will say, yep, I agree with the board's decision, affirmed, or the judge will say, nope, you got it wrong, board. I'm going to, grant the application because the board found all the elements were met except for this one. And the board was arbitrary and capricious when it made this finding, something like that. So.
Right. And then just one final what if. I know, so we're operating in a regulatory environment where cannabis is illegal at the federal level or is like under a different kind of regulatory scheme. And there's lots of conversation about when and how that might change. But like at the end of the day, like even if things shift at the federal level, like we as a city are still, and like we as a board bound by BRC, like federal changes wouldn't sort of trickle down immediately, but some kind of federal action wouldn't sort of like have an immediate effect on our BRC and our board if things shifted at that kind of level. Or is there any situation where something could happen at the federal level and that could sort of impact BRC decision or sort of the BRC or sort of decisions we make as a board?
So I won't go into the different ways in which somebody could try to sue us in federal court. I mean, obviously you've probably heard the kind of the thought, well, somebody can sue somebody for any reason. That doesn't mean it's going to stand in court. That doesn't mean it won't get dismissed or, that they'll lose on a motion for summary judgment or, there's kind of liberal leeway in our system to sue people in. So I'll say that, but the administrative mechanism they use for suit goes to Boulder District Court, and that court will review it for compliance with state and local law. It's very, very rare that court would ever hear a federal issue. And at the same time, the kind of, I guess, the inverse of that is Boulder has a lot of authority to apply its laws in the sphere of marijuana. There's not many, I can't think of any instances where we're what's called preempted from deciding something under federal law. Like it's a very, very much hands off, right? So it's, I think it would be really, I can't envision a situation where that would happen right now. So,
All right. Thanks for all that advice.
yeah. So unless anybody has anything else, Chairman Kunzman, I think that's all we got for the script for right now, with the caveat, I think you thought, and I think the board thought maybe it'd be prudent to run through like just a mock
Yeah,
hearing.
we talked about that, yes. Everybody good with that?
At the next meeting.
See thumbs up.
And so if we have a break slotted in somewhere, the next big piece is obviously the kind of the bulk of tonight's meeting. And I don't think it'll take too long, but I don't know if it makes sense to take our break now before I get into it, or what, how would you?
It's a bit early. I mean, although I guess during break, I could check and see what Michael's situation is and see if he can join us.
Chair, I'd appreciate a 5-minute break if we can do it.
Sure. How
Thank
about
you.
we do 5 minutes now? Everybody good with that? Okay, cool. Ethan's back. No, let's go ahead and restart. And Michael will join us when he can, I guess. Oh, there he is.
Hey guys, sorry. I had some filing deadlines.
You ready, Andy?
Yep, I can go ahead and share. So as mentioned, this was the presentation that let me share it here. Got closed captioning in the way of sharing. There we go. So we wanted to hit upon some additional training components. And so this presentation, obviously, hearings, understanding the board's expanded role. So I don't mean to sort of scare you at the outset in terms of hearings. I mean, at the end of the day, you need to just do the best you can, apply the law as it's written the best you can. But I did want to sort of tee this up and start helping you all kind of think about hearings and contextualize, what it means to be a hearing officer, what it means to be in a role of effectively acting as a judge in situations that, again, hopefully aren't too contentious, but kind of mentally preparing yourself for this new quasi-judicial role. So you can see the subtitle, Doing Your Job Comprehensively, Equitably, and with the Spirit of Public Service. And if you kind of keep that in mind, including a few points I'll make as we go through this presentation, you'll do fine. So this is kind of what we're going to go through. So overview of hearings, hearings generally, which we actually talked quite a bit about already tonight. So we'll go through that quickly, but we're going to talk about the applicant's role in hearings, the staff's role in hearings, the city attorney's office's role in hearings, and then, of course, the key part and most of the presentation is your role. So Before we begin, there's a few items to hit upon. I'm gonna try to turn my camera just a little bit so I can see better. So in fact, let me see if I can exit here somehow, maybe not. So the first point, we're covering some basics, which I think we've already covered some basics. You're all getting caught up with your quasi-judicial role. So sorry about some of this, if some of it's basic. Some of it I think you're going to be like, well, duh. But I think it's still worth touching upon. As I mentioned earlier, we're including quite a bit of quotes just because I think it's good, even if you never have to look at portions of the BRC we're going to talk about tonight. I think it's good for you to like put eyeballs on it because in some respects, we're all here to help each other. I'm going to do my best to catch issues with, complying with the BRC, but it's helpful if all of us as board members can help catch issues and just sort of guide each other. And so we're going to touch upon some parts of the BRC, and the goal is ultimately to empower all of us to do a good job. So we'll talk about that more in a second. And throughout this, I really encourage you to ask questions. So there's a couple points where I might ask for anybody to have questions, but if you have a question, just, feel free to jump off of mute and chime in and stop me before I continue going on. So this is really, open discussion here. Hearings generally, the goal, and this is under the BRC. So when you're sitting as a hearing officer, your goal is to determine whether the proposed agency action comports with the requirements and standards and applicable provisions of the city charter, ordinance, or code, or state or federal constitution or law. And so, put simply, your job is to apply the law as written. So most of the time, given how local your task is in particular, it's going to be about applying the BRC. What does the Boulder Revised Code say is required? Are those elements met? But there's another part, and this is kind of the quasi-judicial hearing part, which is obtaining a full and true disclosure of the facts. So most of the facts are going to be uncontroverted. So it's not going to be an issue of, there's not going to be a dispute. There's not going to be a dispute about this fact or that fact. Most of the time, I would guess, the staff preliminary findings and what the applicant is saying are going to be married, and there's not going to be a factual dispute. But if there is a factual dispute, maybe that's the distance of a particular location from, a school or some other issue. If there's a factual dispute, you're going to have to weigh what evidence you have and come to a decision on that. And you're going to want the record to reflect that. So maybe it's a particular document that you found pretty helpful, or it's something that somebody said in the testimony that you found persuasive. So that's fine. But you're seeking to obtain a full and true disclosure of the facts and to make a decision based upon those facts. And then importantly, there's a due process component to all of this. So you're giving applicants their day in court. This is really designed, like most board proceedings, to be not just government officials sitting behind closed doors making a decision without, maybe much communication or opportunity to explain to them your perspective. This is designed to give them their day in court, their day to explain their perspective, explain, what their positions are and why, and to make sure they're heard and to validate, that their opinions matter. So keep that in mind as we go through this. Hearings include creation of a record. This is really key, and this is what we discussed earlier, which is everything is based upon the record. So at some point, if somebody is upset and they want to sue us, a judge is going to see a transcript, just like the one being created down here. That's a bunch of words on a page that has all of us speaking, and a judge is going to go through and evaluate that record and determine, one, whether there's sufficient I'm very much paraphrasing when I say this, but whether there's sufficient evidence in the record for our decision, i.e. whether it's justified. And two, just as important, what were the arguments that were raised? So a big part of this is your job isn't to formulate arguments necessarily for the applicant. You know, if you have to do so to get a correct answer, great. But applicants, as well as the city staff, can waive arguments if they're not timely raised before you. So if people aren't arguing it and raising it as an issue, you know, it's gone. They can't come in and hire an attorney after the fact. I mean, they can come in and they can try to do this, but as a practical matter, if it's not something that is before you all to consider, if they haven't pointed out an issue, they can't raise it on appeal, and then we can't lose on appeal after that fact. So keep that in mind. If they get creative attorneys who come in later and raise issues, that's not something you should be concerned about as much. You should be concerned about, are the elements of the application met? If so, they get their application. If not, you know, why not? And which specific elements aren't met? And let's, you know, make sure we're right on that, but then deny the application if that's appropriate. So testimony is taken under oath, so we'll discuss what that means. But basically, Kristen Teague will probably be the one that swears them in. Or we might have some sort of, we've discussed this briefly, but having like a written attestation under oath that they might complete. So that's only important in the sense that people are obligated to tell you the truth, but it's still prudent of you all to listen carefully about the words coming out of their mouth and make sure you understand them and that they're getting at, you know, if you ask a question, did their response address your question, or did it skirt around the issue and truthfully answer what was not asked? So you're kind of being vigilant. You know, they are required to state the truth, but it's up to you all, and it's your prerogative to make sure that they're, you know, that what they say makes sense and it's getting at, you know, the heart of the issues that are asked. And I'll go back to this, which I mentioned earlier, which is the most likely scenario. We have preliminary findings. You realize beforehand the applicant probably qualifies for a license. You show up to the hearing. Everyone is in agreement that the license is warranted. The applicant doesn't have much to say because there's not much in dispute. Staff don't have much to say. You may not have much to say, you know, unless there's some concern you have that you want to discuss or ask somebody about. And we're able to breeze through a hearing pretty quickly. You vote to approve the application. So that's, I say that's the most likely scenario because I don't think, you know, most of the time, if people are getting hung up with the preliminary findings and their discussions with licensing staff, they're going to be discouraged to bring an application. If they know they're not going to qualify and they're getting sort of pushback from staff, you know, my guess is they're not going to want to waste everybody's time, including their time, and bring in a license that they know is going to get denied. So that's not to say they couldn't do it, right? They can do that, but it is to say that, you know, the process that these applications will go through before it gets to you are pretty robust. And a lot of times, if they're smart, you know, they probably won't even want to push it to a full quasi judicial hearing if they know it's going to get denied. That said, just as any licensing / regulatory scheme has sort of issues arise, there could be issues that arise. There could be genuine disputes of fact. There could be different ways to interpret a provision that, you know, that they want to push and make sure they get a decision from you all. So that all could happen. There could also be instances where they just want to push something. They want to push something as far as it'll go, including taking it to court. And they know licensing staff's position, and they want to, one, vet that through you all, but two, they want to preserve their right to appeal. And so that's an option. That's something they could do. And in administrative law, there's something called basically it's a principle that you have to exercise your rights within the agency. So just because Kristen Changaris gets on a phone call with them and says, no, we don't agree with you on that. We're going to recommend to the CLAB that this be denied for this reason. That doesn't trigger their opportunity to sue us. So they still have to go through the full administrative process to get a final agency decision. And that final agency decision comes through you all. So they still have to go through the hearing process to get to that point where they get their day in court, right? So that's them doing their role. So they're going to have the application completed, and they'll have an opportunity to present evidence. Again, that's probably going to be most prevalent if there's factual disputes. If there's not a factual dispute, if they're just saying, hey, licensing staff is interpreting this wrong, they're probably just going to come in and say that. They're probably just going to come in and give argument either themselves or through their attorney and say that. This is something I don't think that we touched upon with the retreat, but the applicant has the burden of proof. And so that kind of makes sense, right? Because they're applying for a license. That's a legal right. So if they want this legal right, they need to show that they've met all of the elements for a license, and that their site meets all the elements for a license. So that's their burden of proof. Under the law, it's basically, it's called a preponderance of the evidence. So they have to prove to you all that it's more likely than not, as in greater than 50%, that they've met their burden. So, at the end of the day, if it comes to, and we'll go back to our hypothetical distance measurement, if they have to be, more than 500 feet from a particular building, and maybe there's a staff record that shows it's 495, and they come with a record you all find is persuasive, that it's 504. If you find that persuasive, then you can make a factual finding that that's persuasive and grant the license. So that's where the burden of proof comes in. And I mentioned the preponderance of the evidence. And then procedurally, they have these a few rights that are afforded for quasi-judicial hearings. So they have the right to submit what's called oral and written evidence. We've talked about that. They can appear, they can say their testimony, and they can submit written evidence. They have a right to submit rebuttal evidence. So how we handle this is basically the applicant should, to the extent we can, give them the last opportunity to speak, right? That's the simplest way to handle it. If somebody brings up some issue, whether it's another interested party or whether it's staff, that we should try to make sure that the applicant has the last opportunity to address that issue. And then they have the right to conduct cross-examination. So in the administrative proceeding context, that's, boils down to a right to ask questions of the other party. So we should make sure that they have that right to ask questions of staff. Staff's role, they obviously do their whole monitoring aspect, which is, the most significant part of licensing's job. So all of the administrative tasks with continuing compliance with the BRC. That's a whole different animal we won't get into, but that's a big part of their role. And then for new licenses, they have the right to, and they have the role of providing facts and presenting evidence. So a big part of their job is trying to help identify issues. And if there's things like documents you might need to compile those documents, maybe they weren't submitted as part of the application, but they have the right and the ability and the obligation to try to make your job easier by, if there's specific documents finding those and disclosing them to you all as well as to the applicant, and making those a part of the administrative record. So, and we discussed this at the retreat, but it's just worth reiterating. They prepare their staff preliminary findings. Those are part of the evidence. Those are part of the record. But, you know, it's a great start. I believe, especially with, you know, this is obviously my opinion, but licensing staff is really excellent in Boulder. I think they're they're very, very qualified and very, very good at their job and very, very diligent. And I have worked with government staff that I cannot say that about. So, you know, my guess is you'll agree with their findings most of the time. But pursuant to the BRC, it's the CLAB that has the ultimate responsibility for the decision and the ultimate decision-making authority. So just because they think everything is, you know, kosher, so to speak, that doesn't prevent you from asking questions and inquiring further and making sure everything's sort of on the up and up. Staff know that, they know to expect that. In many respects, they, I think, like that role. I don't want to speak for them, but I think there's a lot of advantages to having a public board that, you know, goes through and vets everything and confirms everything's correct. So, they're, you know, they verify the licensing application representation. So we talked about, I think, both as part of the application process, they're going to confirm what they're saying in the application is accurate. And then as part of the approval process, so you're going to grant licenses on a conditional approval basis, as we discussed in the sort of motion script. And after that, they go through a process of confirming everything's accurate. So CAO's role, that's obviously the city attorney offices, and that's Rewa and I. So our role is legal advice, and that's principally surrounding the interpretation of the Boulder Revised Code and other laws. You know, like staff, I mean, we give you our view of what the BRC says. Hopefully, the BRC is written plainly and clearly enough where it's like you're going to see the language that that we're able to refer you to and be like, oh yeah. But that certainly doesn't stop you from reading the BRC and thinking critically about it and, you know, applying it to the best of your ability. That also doesn't stop you from discussing it with the other board members during the debate portion or with the applicants. In many respects, I think when you get to questioning applicants or questioning staff, your questions are going to surround sort of the BRC, and there's going to be times when we have to dive into portions of it, and you might have to critically ask applicants, like, you mean to tell me that this portion of the BRC that says this, doesn't that mean this? You know, or what evidence do you have to show that this is the case? Can you show us that? What does that look like? Why don't you agree with staff's interpretation of the BRC this way, right? So that's all on the table, and it's a very legal interpretation centric sort of sets of inquiry, and it's an inquiry that I can guide you with and give you my interpretation of the law. But as we've discussed previously, there's times when no matter how detailed the law is, or no matter how plainly written it tries to be, there's just, I think the best way you can say it is, you know, we have code that needs to be, try to be readable while still being comprehensive enough to capture as many instances as it can. But there's going to be times when instances, you know, factual instances in the real world aren't provided for in the code. It doesn't directly address how to handle that particular situation, or you know, or maybe it addresses slightly how to handle it, but this is something that wasn't contemplated when the code was written, right? So there's going to be gaps, there's going to be gray areas, and there's going to be times when you as a board need to decide how to resolve those gaps and how to resolve those gray areas for purposes of deciding, you know, what's required for a Boulder cannabis license, right? So that's within your role. It all comes with the, you know, the burden and authority you have to interpret the BRC and apply it the best you can. It's all part of that same sort of caboodle. And then there's the risk and risk mitigation component. So I'll also advise you of, you know, if there's particularly potent arguments, you might get constitutional arguments raised at your level, and they might be raised for the purpose of preserving arguments. And I can opine on some of that. I can tell you it's difficult to do that in a public meeting without giving away the farm, so to speak, to the other party. I mean, I'm not going to sit there knowing there's a party that might sue us on the other side and say, oh, they're absolutely you know, right, you guys have to grant a license. That creates a difficult situation. It would have to be a really extraordinary circumstance for that to happen. So in a sense, you know, there's limits on the extent to which I can advise on litigation risk following your decision. But I think that's a part of this. I think, you know, at the end of the day, we're trying to do the best we can. And you know, I think you as a board need to be thinking about legal risk. It's not to say we succumb to somebody who comes in and bullies us. Like, that's the opposite of what we do, in fact. But it is to say we need to be cognizant of that back end risk. So, and then finally, the advising on the adherence to procedure and open meetings laws. So we've discussed a lot about procedure tonight already with the script discussion, but at the end of the day, you know, we need to consistently apply our procedure. Litigation, if an appeal occurs, so that will be, we have a litigation team that are very good at what they do in the city. Chances are, if an appeal happened, I would probably become part of that litigation team, at least as a second chair. There's a chance I could handle the appeal solo. I don't know, but that's all part of the role that CAO will hold, is taking whatever decision you make and going in and defending it to the best of our ability. So, and then we get into your role. So I mentioned the hearing officer, AKA the judge. So, you know, you're obviously not anointed judges within the state, but you have a role of hearing officer, which is an administrative title that, you know, expects you to conduct administrative hearings. So what do judges do? That's going to be what we're going to focus on for your role. Preside over the hearing, you review and understand the facts, you discuss the record, and you render a decision, again, to the best of your ability. And we'll get into, I don't remember why I had these, like, I don't remember why I had these originally. So I hope you enjoy those images as much as I do. So, oh, let's learn about being a judge. So let's put on, you know, pull out, that's what I was going to say. It was going to be really clever and smart. Let's put on your judge's robe, pull out your judge's gavel, put on your judge's wig. I don't know if that's what they were called back in the day, but and let's focus on what it means to be a good judge, because that's what you're doing, is you're upholding people's due process rights and you're giving them their day in court, right? So what do judges do? They prepare. Coming into hearings, you should have reviewed the application. You should have reviewed the staff's preliminary findings. Again, a great start, but you need to be comprehensive. You have the ultimate say. You'll have reviewed, hopefully, portions of the Boulder Revised Code. So if there's portions of an application that, you know, are at issue, there's going to be some portion of the Boulder Revised Code that makes those at issue. And so hopefully you'll have a chance to at least read that little snippet or portion and kind of developed a thought on what's required, right? And maybe thought about, why is it required? Okay, what was city council thinking when they wanted this particular requirement in place? What makes sense? What was the intent underlying the original Boulder Revised Code language? Judges manage the proceedings. So they decide who gets to speak, when do they speak, how's evidence received. We have a script that hopefully makes that all pretty easy, streamlined, and consistent. So hopefully that's not a sort of too much of a hurdle for you all. But there is sort of an obligation to manage the proceeding, right? You don't want people interrupting each other. You don't want people speaking out of turn. We lay out the rules at the very outset of the hearing so that there's order to it. And, if attorneys appear before you all, they're accustomed to seeing order and they like seeing order. And so they'll, I think, be inclined to adhere to that order, assuming they're not sort of belligerent. But there's some people that might appear that, don't respect the process and sticking to time periods. And so we have some prerogative just to keep everything equitable for ensuring that happens. So I mentioned this earlier, but objections are really a key part of managing proceedings. So, and this is mostly looking to Tom and Brian, in your roles as chair and vice chair, Brian, if you're presiding over the hearing. One of the most powerful things you can do is just ask if there's an objection. And I can't say when all that might be necessary, but if anybody starts doing anything that, seems unfair or seems inconsistent with our regular process, one of the easiest things you can do, and I'll remind you of this, is just to turn to the other side and say, hey, do you have any objection to this? And obviously we're most concerned about the applicant's rights. So turn to the applicant or their counsel and saying, does the applicant object if we do this or that, or, take in this evidence? That can resolve a lot, because most of the time there's not going to be an objection and everybody wants to get along and keep the proceeding moving smoothly. So you can just ask people. This is
Andrew,
yeah.
break it up a little bit.
Yeah.
Those wigs are called perukes. Do you think Brian and I could get one of those perukes, or each one of us could, then we'll have the air of authority I'm joking, so obviously.
I love it. I don't think it would undermine your authority at all, Tom. No, just
I think Brian and I would especially benefit from having such a thing.
I like being streamlined.
Yeah, right.
Okay.
Everybody will know who's in charge. Yeah. Yeah.
All right, sorry. Just wanted to break it up a little, Andy, there.
Yeah, no, good.
And
I
learn a
didn't know
new
that.
word.
Yeah.
Peruke.
Okay.
Peruk.
Yeah. Yeah. I don't know when the judiciary stopped wearing those, but yeah. So this is getting at, so I think this is good for you all to hear, just so you understand. I'm talking a lot about being a judge. No, everybody realizes you're not judges and you're not attorneys typically, most of you. But there's some recognition, right? The board is not comprised of attorneys and judges. It's comprised of subject matter experts and concerned/interested persons. This is common for boards. This is, in fact, one of the primary purposes for government entities setting up boards. Is we need to have the people who know the most about this stuff, whatever it is, deciding matters of public concern, right? You're the subject matter experts. And so we'll get into this in a little bit, but you're allowed to consider your subject matter expertise as part of this. And in fact, you have to stick to the BRC. I want you to apply the law as written. That goes without saying. But judges, when they review board decisions and agency decisions, they're going to be cognizant and respectful of your subject matter expertise. So we can talk about that in a little bit, but just keep that in mind as you go through this, that you're not, required to take off your subject matter expert hat. You all have different perspectives. As long as we're public with those perspectives and have discussion about them, that's okay. So, and I'm going to say, so this is the least legalese statement ever made, but these are kind of the core principles that I would say that if we were going to like kind of grab onto our values for purposes of acting properly as a board, it's this: we will be okay if we treat people fairly. That's everybody who appears before us. Treat them fairly, treat them with respect, act transparently. It for a variety of reasons, it's better if we act transparently. I mean, both ethically, but also for legal reasons. I mean, to keep issues from blowing up later, just act transparently, be transparent, disclose things, err on the side of disclosure. And then C, apply the law in good faith, and as faithfully and objectively as possible. So, your goal is take the BRC and do what City Council told us, because the City Council is the legal representatives, duly elected persons, right? They create Boulder law. Let's try to effectuate their underlying intent as best as we can. That's really, really important, and it's easier said than done, because you'll find maybe when we get into some complex issues, that might be hard to try to decipher what they wanted. But that's our job, and it might create some issues where we have to really pull on some threads to figure out, what the facts are and what they wanted and what each party's position is. So moving on. So judges, they review and hear evidence. And so this is one of those long quotes that I nonetheless wanted to give you just so you can put eyeballs on it. And we'll go through the important parts. So the hearing officer may receive all or part of the evidence in written form, if the interest of the parties will not be prejudiced substantially, or if the hearing will be expedited thereby. So as a general rule, we can receive written evidence, whatever that might be, but somebody could object, right? And if they're going to be prejudiced by receiving evidence, then we should consider either receiving it in oral form, i.e. having somebody testify to it, or at least giving them the opportunity to, raise that objection and discuss that. And so the most common reason why this might become an issue is if, for example, somebody is objecting to what's called the authenticity of a document, as in like, oh, that's not the most recent version of that federal document, right? Or those aren't the real property records, or something like that. So that's going to be extremely, extremely rare, but I wanted to raise that there. I.e. written evidence is okay if one objects. The rules of evidence, which we won't get into much, and I hope not at all basically in hearings, but we do have an obligation to conform with them to the extent practicable. I.e. the rules of evidence apply, the court rules of evidence, but here's the caveat. We can even consider the evidence if such evidence, quote, possesses probative value commonly accepted by reasonable and prudent persons. So basically, if it's something that you all deem probative to the issue and reasonable and prudent persons would accept it, i.e. you think it's accurate, you think it's reliable, you can consider it. So You may receive documentary evidence, so that's basically the same thing as the written evidence. If the copy is authenticated, we discussed that. Is it reliable? And you probably may, I don't know if your closed captioning sits on that, but basically documents can serve as evidence that document is complete, not altered, and it is what it claims to be. And then here's kind of an important piece. The hearing officer shall, it's not a may, it's a shall, i.e. you all shall, use their experience, technical competence, and specialized knowledge in evaluating the evidence presented to it. So if you know, for instance, and this is maybe the most obvious example, but it's okay for you to say, I've driven by that area before. I know where that is. There's this there, there's that there, right? It's okay to consider that. You know, I would encourage you to, whatever specialized knowledge you bring in, allow the applicant and the other parties to discuss that and opine on that. But it's okay to bring that into the proceeding. Yeah, and it's you should, nay, you must use your specialized knowledge and judgment. So, any questions about any of that before I move on? So we're getting close to the end here, I promise you. So judges let people exercise their rights. You know, we discussed this. Make sure the applicant has the last chance to respond. This BRC section 1-3-5 says, quote, parties to the hearing may make objections to evidentiary offers, which shall then be noted in the record. So they have a right to object, and we'll note it in the record. In the absence of an objection, the hearing may be conducted informally, and the failure to request any procedure shall constitute a waiver thereof. So as long as we're giving people the opportunity to object, you know, they can exercise their rights, and they can retain an attorney who can help them exercise their rights if they want to. But if they don't object, they're consenting to the process, and they're consenting to the admission of evidence and everything else. So just kind of keep that in mind. Judges, so they keep an open mind and are respectful. And this is, Tom, getting back to the levity of all this. I do have some videos that we'll go through real quick, starting with this Judge Judy clip. And I assure you, it is, you know, I thought we would have more time at a retreat to discuss some of this, but we'll go through some of this. And I want you to pay attention a little bit to her demeanor. There's a couple of things that are good things that Judge Judy does that we'll discuss, but for the most part, right, Judge Judy is TV entertainment. And so she'll act and behave in ways that are designed to entertain. They're not designed to make people feel heard, appreciated, respected, and have their positions, you know, fully considered. They're designed to keep things moving, entertain, and that's most of why we're watching this. So let's start with this first one.
We don't have audio. Or do
Oh
we?
no.
Not yet.
Let's see. Kristen. Oh, sure, Sam. Let's see.
She is going to continue
hear
to
that?
make everybody's life miserable. Mrs. Lord, you are a charming lady.
Thank you.
I
think you're charming too.
thank you. I have not. Thank you.
Can you hear that?
At the risk of being
Yeah.
disrespectful, you can't be a pest to all of your neighbors. They are entitled to the peaceful enjoyment of their home, just
Right.
as you are.
Am
just
I?
as you, absolutely, just as you are. But I'm not hearing the case now against either Mr. Vibot or the city council. I'm hearing the case of these innocent people who have been caused to suffer because you are protesting something that has nothing to do with them. And Ms. Lord, you have to stop. And if the only way to get you to stop is to start charging you money for this violation, then I am going to start charging you money. But this award of money that I'm making to you today is up until today's date.
I have
I'm making
finished
that
my
very,
presentation.
no. Yeah, now you have to be
not
quiet.
finished my
No,
presentation.
listen to me. Now you have to be quiet. I want you to understand this, that this award that I am making to you today is by way of a warning. It's going to cost her $1,500 if she does it tonight, if you file suit. It'll cost her $1,500 again next week if you file suit. You've got to take your anger out at the right people. The judgment of this court, listen to me,
finished my
is
presentation.
you finished.
I
That's
haven't.
I finished. It's
I haven't.
$1,500 and you better stop playing that noise.
I
Case is
protest.
over.
So, you know, you can see how Judge Judy's sort of demeanor, again, it's all entertainment. I bet she was probably, when she actually was a real judge, she was probably a very good judge. She's very smart, witty. I don't know what was going on with that dispute. It was some sort of property dispute, I think. And but you could see how the woman reacted when Judge Judy said, "You're a pest." She called her a pest. And that might be, who knows, whatever that means. But the point is it didn't help anything. It just made her angry, made the lady feel like, whatever rights she has in this fake court were being stepped on, and it made her kind of defiant and angry. And when people are defiant and angry, what do? They sue. So, your job as a board isn't to convince the applicants they're wrong. It's great if you can get them to agree that they're wrong and they're not entitled to a license. If that's the case, right? If we get consensus with them and they're saying, "Oh, yep, you're right," that's fantastic. But you're not there to prove you have some authority over them or are smarter than them or anything else. It's, let them present their case and arguments and let them be heard. And as long as they're operating within the procedure we've laid out, let them say their piece. So one of the things that struck me with that video is if you were an attorney and your client was being treated that way by, say, you all, a board, a district court judge would not like that, right? And I have no doubt that just based upon the people on this board, that you would do that. But you might get instances where an attorney comes in, maybe believing that their client doesn't have a super great case, and that attorney might try to antagonize you. I've maybe you've heard stories in the media about a certain presidential candidate that is reportedly has attorneys that are antagonizing the judge. Sometimes attorneys will do that. Sometimes attorneys, if they think they're going to lose anyway, they might try to make a mess of a record, and they might try to, cause you to act unprofessionally and in ways where you create statements or records that they can then use against you, and they can turn around and say, "Look, judge, look at how my client was treated." They might actually use that as a tactic. And so I would just, be conscientious of that. Judge Judy wasn't letting her presenter speak, raising her voice, right? There's basically no reason for you all to ever raise your voice on anybody who appears before you. You don't need to do it. It's not helpful. This is a piece. So if you heard Judge Judy say, "This award that I'm making to you today is up until today's date." So I think she was misstating there. I think she was making an award to the other couple that was standing there, and it almost made it seem like she was making an award to that woman. And I think, if you saw the video, you could correct that, or a judge would understand that. But that kind of goes to making sure that the record is clean. Like, if you hear one of your fellow board members say something that's clear that they probably meant the opposite, jump in and, do the point of clarification or something. Like, just go ahead and jump in and make sure that that's correct. And that doesn't sit there on the record and potentially create confusion for a judge. Because remember, a judge they're going to be looking at the written record most likely. They might watch the video, but if the written record looks confusing, that might confuse them, right? So just correct that, nip that in the bud, have them correct their statement. So we'll move on to this next clip. I'll say before we start, so for this, she clearly had read some things beforehand or had an idea of how she was going to rule. And just think about how this record might look.
Who broke off your relationship in August of 2016?
I don't recall, Your Honor.
Do you remember?
I did, Your Honor.
You did. Tell me about how you broke off the relationship.
I called her and I told her I wanted to work things out with Rocio.
Did he ever tell you that?
No.
She's lying.
No. Actually, it's only one liar standing there. That would be you.
So, I mean, obviously calling
Who
somebody a
broke off?
liar helps nothing. It does nothing. Even if you think somebody's misleading, you know, at the end of the day, you can discuss that during debate. And I think there's tactful ways that you can do that, which is saying, you know, we understand that so-and-so said X. We think, you know, however, we've reviewed Y, we've reviewed Z. We think those are more likely. We think X is not likely because of this, right? So there's ways that you can address that. You don't have to call people out or call them a liar, or, you know, you can still ask questions of them, right? Still get, you know, I think you can make it so that they can get confused and or make misstatements on the record, sure, but you don't need to call people out personally, right? And then the laughing wouldn't help. That would be a terrible record if if you're sitting there laughing at somebody who's appearing before you, or you know, you want to use as much restraint as you possibly can, right? Because if you're not using restraint as a board, you're opening up the board for risk of, one, people getting upset and just deciding to sue us to prove a point, or two, you know, a court being upset with your demeanor and behavior. So so that's all what we just went over there. Treat persons with respect and dignity, everybody who appears before you, right? And then this is the last clip. And what you can watch for this is watch for how the documents are exchanged. Again, she calls somebody a liar. Is there a sufficient basis for that? Or maybe she just alludes to the fact that they might be lying. And if you were a judge reviewing this, what would this look like? So
Deneen Ratchford is suing her ex-boyfriend, Eric Miller, for unauthorized credit card charges and the accrued interest.
Ms. Ratchford, it is your claim that Mr. Miller, who was your boyfriend at one time, used your credit card and owes you some money on that credit card.
That's correct.
It's a credit card that you used as well as Mr. Miller, or it was only used by Mr. Miller?
90% of it was Mr. Miller. I used it for one charge.
One charge?
One charge.
What was that one charge?
A plane ticket for my mother.
Why did you use that credit card for the plane ticket?
I was at my mother's location, and I didn't have my other credit cards with me, so that was the one credit card I had in my wallet.
We're going to get back to that in a minute. Mr. Miller, why did you take a credit card from the plaintiff?
Your Honor, I didn't take a credit card from the plaintiff.
Explain to me whether or not you used a credit card that was in her name.
I did not use a credit card that was in her name. We had did some business on a prior situation. There was no credit card outstanding debt. I never used a credit card.
Okay.
I have any credit cards.
May I see the credit card purchases to which you refer?
Yes. Right here. All of the purchases that are related to Mr. Miller are highlighted in pink. The purchases that are related to myself are highlighted in yellow. He was an authorized user on the account, so he had his own card that had his own name on it, but I was the primary account holder.
I'm only interested in the charges that he made under his account.
Which is everything that's in pink on that card, on that statement.
Would you show this to Mr. Miller, please? First, look and see the name of the card holder. What is that name?
It says Deneen Ratchford.
No, I'm talking about the one that's yours, Mr. Miller. Start with where the pink is.
I'm looking at the pink.
Do you want me to make a big circle around it?
Yeah, because I don't see my name on here anywhere.
Okay, may I see it, please?
Okay, I say that. Lancaster, Shell, Home Depot. I didn't make any of these charges.
I don't believe you. You even acknowledge in your answer that you made the charges.
I even acknowledged in my answer that I made the charges?
Yeah. It was some sort of something that had to do with refurbishing your house in order to sell it. It had to do with some girlfriend or something. I don't know. I didn't pay attention to that part of your nonsense. But there is no question that you made the charges where it says Miller. She had her card, like I have my card. It says Judith Scheindlin's charges, Gerald Scheindlin's charges. Those are your charges. So when I say I don't believe you, I want you to follow my words. I don't believe you. Now, you want to make up a better story?
So the big thing that with that portion was how they exchanged the documentary evidence, right? So she had a document, and I think in your world, these documents are going to be hopefully displayed on a screen, but you'll need to make sure everybody's looking at the same thing. So if you're looking at a specific portion of the application, you know, the applicant needs to know what you're looking at and referencing. And so you can say, I'm looking at page 3 at this section. Do you see where it says this? Get the applicant on the same page, get all the board members on the same page, you know, and get a reviewing court understanding what it is that the board was looking at when it was, you know, making this decision, right? So that's really important. It's not enough to just say, well, I looked at the application and it said this. I mean, try to hone in on specific statements within the application you think are relevant, or specific statements within the staff findings, right? Make it abundantly clear to everybody, not just in the proceeding, but also if it gets appealed, you know, what it is that we're looking at when we're talking about specific parts of the elements of the license, right? So we just discussed that. And then again, with the demeanor, you know, the accusing the guy of lying, it's not helpful, not providing the opportunity to speak, not really, he filed an answer and she didn't really, you know, it was clear she didn't really read it and didn't really care. I mean, that's the opposite of what you want to be doing. If people file something with us, I mean, pay attention to every word in that, because we want to make sure with every single section that if we're going to deny a license, that we are correct in that denial. And we fully considered what their position is. And if they put it in paper, you know, pay attention to it, give it some sincere thought. So before we move on, are there any questions about any of that, of the demeanor stuff or records, or any thoughts on any of that?
I have a question, Andy. Say you had something come up with a document, you were saying earlier, you know, maybe there's a better version of it out there, or what have you. Would you table the matter, or do you just keep going, or what happens with something like that?
Yeah, so you could always continue the hearing if there's something big like that comes up, right? That's an option, and it would hopefully be a continuance with the hope that staff can hunt down the most recent version or whatever it is, right? You know, hopefully you would have the person, authenticity is the big issue, right? So hopefully if somebody downloaded something from a website, you could have them say, you know, and this is an accurate copy of this web page. I think that's hopefully the way you would deal with it. The board could, as long as they have an opportunity. So if the board needed to pull up a web page or find a document that's not in the record, you can do that. You just have to make sure that the applicant, or, you know, or whoever the other interested parties have an opportunity to object. And we have to make sure that it is what it purports to be, essentially. So yeah, and Kristen Changaris or Kristen Teague, have you guys ever had an instance where that came up for BLA? Or, I mean, I can't think of anything right now. Yeah.
I can't think of any instance where the Beverage Licensing Authority has pulled up a website per se. However, I will make note that occasionally we do get an updated piece of information after the hearing packet has gone out. When that happens, it becomes an exhibit to that agenda item, and that exhibit item is then posted to Laserfiche, which is our city repository where you can locate the agenda and the packet. But then a copy of that is also emailed to the board members and staff. So paying attention to emails to watch for things that those come across, because sometimes those do come across, you know, the day of or hours before an actual hearing date with experience from BLA hearings.
Yeah, and if it's complex enough that, you know, and if it's significant enough, as in it can change the board's decision on an issue, the applicant might want more time to review it and might want to continue a hearing. So we gotta kind of be careful with that. I mean, a lot of it is circumstantial. Has the applicant had enough time to consider it, and have you all, and what does it mean? So,
and we have seen the BLA err on the side of caution and continue to the following month's hearing.
any other thoughts?
So Andy, with respect to Brian and my role, and I don't anticipate or expect that this would come up in these presentations by businesses. But then again, you never know. Because I remember at times during some of our public comment sessions, I would be watching carefully the meeting ground rules and trying to decide whether some people commenting were treating others with respect and dignity. And it was sometimes bordering on wanting to step in, which I don't think I ever did. Maybe, Brian, do you remember ever having to step in?
There are only some meetings with the former board member that I felt like the need to step in, but
yeah, but there are some public commenters who have even been informed by the city of the expectations. One in particular that we all know, but really it's more in general. How do you recommend? I mean, I agree with you 100%. And I do try to treat all persons with respect and dignity, but also it's a quid pro quo, or it's a.
Yeah, I mean, they need, you know, you don't have, I guess, unlike a judge, I'll say, you don't have the right to put somebody in jail or fine somebody, right? Your authority is limited to, is the license granted or is it not? So my guess is people will be coming in minding their best behavior most of the time, especially since they're businesses. I mean, the cannabis businesses are typically, it takes funding and it takes sophistication to do some of that. You know, those are, I guess, some subjective opinions on my part, but it's not like you have a bunch of members of the public who have gotten tickets who, you know, might be coming in to appear before you all. I would assume they would be operating okay. I think there's a broader discussion, and I know Ree was on the call. There's a broader discussion that we might have about strategies for how to address that in a way that doesn't just unnecessarily escalate it. And I think there's a hard principle that you can, you know, a hard stance that you can take that basically says if it's done remotely, that if somebody continues talking, we're going to mute them. So that might be one tool in the toolbox if somebody's just belligerent. But, you know, aside from that, I think it's making sure they adhere to the process that we set out at the outset of the hearing and adhere to the board's rules and adhere to the board's decorum discussion that Kristen brings up, and re-referring people to that to try to get that extinguished. But, I suppose if somebody were so out of line, we could either continue it until things have calmed down, or we could, I would need to think about that some more. So, and Rewa, if you're on and have any thoughts, we're Kristen Teague or Kristen Shangaris, feel free to jump in. So. Any other thoughts? Okay, we're almost done here. So, what do judges do? They understand and narrow the issues. So I should have probably moved this up earlier because this is a big part of how you can really help the city out generally, is making sure you understand exactly what they're arguing and why. What is the applicant arguing if they're contesting, staff's decision, or vice versa? What is staff arguing? Understand it and narrow the issues. What I mean by that is get as much agreement as you can in the room as possible. So a big part of your job will be kind of sifting through sort of the fluff and different statements that people made, and just, hit people point blank early. So what you're really saying, staff, is this, and what you're really saying, applicant, is this. And applicant, your position is this because of X and Y. Is that right? And get them to commit. And if they say no, well, what else is there, right? Get them to state as simply as possible what their respective positions are and issues are. And for staff, it's probably going to be, I think, plain as day in the staff preliminary findings. I mean, that's going to say staff issue is this because of this. So you're probably not going to have to do that with staff. I would assume, you might, and you have the right to, but with the applicant, they might come in confused about things, or they might come in and present all kinds of arguments intertwined in this sort of passionate, diatribe. And, don't let them do that. Get them to boil down the issues. Like, what is it that you're truly arguing? And that can help both for having you all, one, truly understand what they're saying, but two, it can keep it so that they don't just have this hodgepodge of random things that really aren't argued in a meaningful way by them and really aren't at issue. And it gets them to narrow it down. Okay, here's this point, and here's why that's important in light of what the BRC requires. Let's get at that. Let's address that, and let's address these things one by one by one, so we can have, as a board, a good decision, and so that you, applicant, and you, staff, can be fully heard, right? So I think I have an underline. Yeah. So the parties may make objections, which will be noted in the record. And we reference this, but the hearing shall be conducted informally, and this is the key part. And the failure to request any procedure shall constitute a waiver thereof. So if people aren't raising an issue, they're waiving it. But you got to understand what issues they are raising exactly and why they're raising them, and hammer that point home and get to that early, because that is just going to make the hearing go better. It's going to make everything easier. And it really reduces, of everything on this that reduces our risk, it is that part. It is, I can't tell you how many times, if people are just coming in and trying to raise any and all sorts of arguments, like when it's easy for them to do on paper, but when they sit there in front of you and they're answering questions, people will acknowledge things and they'll agree to things, and they'll waive arguments. They'll say, okay, you have a good point there. Like, if you're just pointed, respectful, but pointed enough, like, this is the case, isn't it? They're going to be inclined to probably move beyond things rather than try to fight something that frankly reduces their credibility, right? But it's up to you to sort of, be on top of that and make sure they commit to that, right? And then I think this is the last one, number 7. So they interpret and apply the law. So most important thing, you're giving the effect to the intent of the Boulder City Council. What did the Boulder City Council want when it adopted a specific part of the BRC? And your duty, you need to faithfully interpret and apply the law as it's written. Try to be as consistent as you possibly can. That means if there's some gray area that you decide in a particular way, in 2024, if that same gray area arises in 2026, to the extent you can, remember your decision and apply it the same way and everything, you really need to do so, right? Consistency is important. That's not to say there won't be good reasons for departing from some decision you made in the past, but it is to say that you should try to, be consistent in how you're interpreting the BRC. And if you grant a license under one circumstance 1 year, interpreting the BRC, and the same set of facts and circumstances arise for another applicant, you should try to grant that license as well. You should try to adhere to your prior sort of precedent. So you should avoid trying to interpret or apply the state marijuana rules unless the BRC requires it. So we can get into that on a case-by-case basis, but your job, we get into sticky areas when we start trying to apply the med rules. And so for that reason, we should try to stick to the BRC, which is our code, as much as possible. If we have to get into med rules, that's fine. But it runs the risk of having us come to an interpretation that the med disagrees with. So as a principle, we should try to avoid that. Let the Marijuana Enforcement Division, i.e. the state, apply and enforce their rules. They got to get a permit through the med anyway. Let them apply their rules. Let's focus on the BRC. Yeah, and then so there's 2 sections of the BRC, which Riwa and I will provide the entire BRC to you all. Those are online as well, but we'll provide you a copy of the BRC. There's 2 sections that are going to be at issue. I'd imagine basically everything we do is found in those 2 sections. So don't start thinking you need to dig in other parts of the BRC unless it's somehow raised by an applicant, because you really won't need to. It's just the two sections, and they're meaty sections, but hopefully by the time you get accustomed to reviewing applications and the elements involved, you'll be able to start realizing where the sections are and what you need to be looking at. So interpreting the law. So this is one point that you'll hear me reference if there's legal interpretation questions you have, but generally the law is interpreted according to its quote unquote plain language. So if possible, you should really just use a plain language interpretation. What does that mean? When I read that, what does that tell me? What does it mean? What's the dictionary definition, right? In essence, if there's not defined terms that are contained in the BRC that you're applying, what does the dictionary say? What does this language mean to an ordinary person? The specific provisions control over the general provisions. So if there's something that generally maybe could be on point, that's not as helpful as something that's specifically on point. So keep that in mind. Always look to the definitions that are contained in the BRC. Always think about identifying what's the intent of the law. What did the Boulder City Council, desire? And then they create a record for appeal. So we've discussed that. The record, it should be easy to understand. We should understand exactly what licensing's position was, what the applicant's position was, and what your decision was, and then the rationale for that decision. So that's all built into the script. The script's designed to walk us through that process. And we want to create a record that's capable of review. So important, unless otherwise provided by city charter, ordinance, or code, or by state or constitutional law, the decision of the agency or hearing officer is final, subject only judicial review pursuant to this Colorado Rule of Procedure 106. And then so this judicial review, and then here's the part that's important. No defense or objection may be presented for judicial review unless it is presented to the agency or hearing officer prior to the decision thereof. So again, if you go in and narrow issues, if somebody comes in and on paper, they started arguing some point and then they later concede that point, they've waived that point. They can't then later raise that point on judicial review to a judge. Keep it simple, make them stick to the issues, make sure you understand all the, evidence that they're presenting on a specific issue, and then make a reasoned decision to the best of your ability. That's all you can do. So, conclusion, ultimately, if you prepare for hearings, right, read everything in advance, behave like a judge, treat people fairly, prepare for hearings, listen to them, allow them to speak, apply the law as written to the best of your ability, and create a good record. If you do all of this, so a record that clearly articulates the parties' positions, you work collaboratively with your fellow board members to understand each other's positions and create that record, and you clearly state the board's decisions and rationale. If you do all of that, we'll be fine, right? At the end of the day, do the best you can. If we get sued, we get sued, so be it. Government gets sued all the time, unfortunately, right? That'll happen. If we get sued, we get sued. But do the best you can, read, prepare, behave appropriately, treat people with respect, apply the laws written. We're going to be fine. So that is it. And so if there's any thoughts or questions or concerns, I think that's it. So.
And before Michael got on, we agreed that we were going to do a mock or watch a mock alcohol decision, right? For next month.
Cannabis, yeah.
Oh, a mock cannabis one in the format of the alcohol. Okay.
Of the script that we just went through. So I think you're right, Tom. I think at one point we discussed
well, we do have the option of watching the alcohol one. Right, that's usually in every packet, if I'm not mistaken.
Yes, there are many different BLA hearings to watch. We would highly encourage everyone on the board to review one before January, just to get a sense of how a quasi-judicial hearing process works.
So I hope I didn't scare everyone or overload everyone's brains. It was all with good intention that you be prepared as you can be for the different exigencies that could arise. And hopefully
Sorry to interrupt. I was just going to say, I really appreciate you really put a lot of time and thought into the presentation, and the Judge Judy thing was entertaining and made a good point. So thank you.
Just echo the same thing. Appreciate all the information, and the examples are fun, right? Because they can get to the heart of what you're trying to say. So appreciate it.
Yeah, thank you, Andy.
Yeah. And that's all I got. So yeah, thanks all for listening to me.
So just so we understand, how do you want to do it next month? Are you going to take it to the point of like having not actors, but somebody like in the role of a business bringing their application to us? How do you want to do it?
Yeah, we'll put that together for the board for next month. But essentially, what we're planning to do is have staff play the different roles of a hearing, and then you all will have the opportunity to run through the script and ask questions as if it was a real hearing.
Okay, will you use some past application, the skeleton of some past application with names changed or something like that? Or how will you create the scenario?
Yeah, that's a good question. We haven't started working on it yet, to be honest with you, but it'll probably, we'll use past examples that we've received as like real life examples of what you might encounter.
Well, especially if you could find some application from the recent past that may not have been straightforward or something like that.
Yeah, we'll use real world examples for you all.
Okay. We get some really cool actors. Just kidding.
We'll do our best.
Is the goal to increase our confidence or to test whether or not we can handle situations?
I think our goal is to increase your confidence in the process. So.
And to make sure Brian doesn't go into a Judge Judy impersonation.
That's me.
Yeah.
Is that why we were watching those? We want to be like Judge Judy? No, it's
That's right.
okay. Are we ready?
Great.
Do we? There's not a whole lot of other things on the agenda. If I'm correct. So I'm not sure we need another break. We could just forge on ahead. Is that correct? Do we all agree? Perfect. All right. Let's do matters from the regulatory. Well, was there anything more? I think that was it, right, Andy?
Yep, I'm done. I've talked a lot. Thank you so much for listening to me and hopefully absorbing.
I'm glad you weren't sick. That would have made it really challenging. Okay, matters from the regulatory licensing office. Who wants to go?
So we don't have too many matters to discuss tonight. We just talked about the January mock hearing, so just a heads up about that. Also, the January meeting has been changed to Monday, January 8th because of the New Year's holiday. So just a reminder of that date change. Board recruitment will be starting in mid-December, so we'll share that information with the board once that has opened. Again, please help us spread the word. If you know anyone that might be interested, please send them our way. We're happy to connect with them and answer any questions they have and get them set up with the recruitment process. And then we're always open to agenda topics for future CLAP meetings. If anyone has anything they would like to add to our list, please let us know.
Just to make sure it's real obvious, we're not returning to real meetings in the near future, so that's a virtual meeting.
Correct.
Right? Okay. Okay.
And then Tom,
Any
I had a
questions?
question. Yeah.
Yeah, go for it. Sorry.
Just had a question about the topics. I know that we had talked previously about the state rule changes for 2024. I know they don't go into effect until January 8th, but I didn't know if the city attorney's office or anybody was going to come with any kind of summary of the changes that occurred at the state level in the months ahead.
I hadn't planned on doing that, but I know Kristen and I have exchanged emails about the changes. It's
or if
been,
the med could, or we could reach out to the med and see if they would do it in February or something.
We've had them before. They might be interested.
Yeah, we can certainly reach out and see if someone would be willing to present. I don't know. January meeting probably will will be full, I think, with the mock hearing. So maybe we can shoot for February if that works. We'll check with our Med Connections and see when they might be available.
On that particular topic, I saw the Boulder County went through a process of, red lines and then a commissioners meeting to look at the incorporation of the new state guidelines into the unincorporated counties code. Are you going to go through a process like that?
Robin, I'm not really familiar with what the county did to speak to that. But if there are any state rules that conflict with our local regulations, then we would likely look at an update to our local regs so that we're not in conflict with anything at the state level.
Okay, I'll share that what I got with you if you're interested. You can probably get it on your own, but I'll share it with you for what it's worth.
That'd be great. Thank you.
Robin, are you saying that there's some changes that might influence or come to play?
I didn't find them to be super consequential. They were, kind of administrative details on the code. And the red line shows the difference between what's currently written in the county's regulations and what they were trying to update to the state code. So, yeah, it wasn't super consequential that I could see, but they did need the commissioners to approve it.
Does the county have someone who is kind of like their go-to on cannabis issues, or?
It seemed like it. I can't remember the people's names, but they were presenting on behalf of staff, Boulder County staff at this hearing, similar to Kristen and Andy and Kristen.
Just I'm playing around in my brain about maybe having that person or someone who would be identified as that person attend one of our meetings and just have a conversation.
Yeah, I guess maybe look at I think the med would be better because you'd get the state level point of view layered on more of our regulation in the city of Boulder. So I think that would be more relevant.
Yeah, and Robin, to your point, I think that they were also going through some changes before the final rules came through when they were finally approved in November. So,
gotcha. Okay.
Okay. Matters from the chair and members of the board. I don't think, Brian, were there any articles that you? Yeah, I'm not sure. Does anybody else on the board have anything they want to bring up today?
there were a couple of articles in the packet or links to articles. If people didn't check them out.
I shared an article, but we had a brief discussion about it in an earlier board meeting. I thought it was interesting. Again, it's not a direct line, but it's kind of some evidence that I think is concerning and worthwhile for us to keep in mind.
I'm looking through the packet right now. What page does it start on?
It is on page
74? 70, no,
61 and 62 of the downloaded packet.
Yeah. Oh, okay. Okay.
Then I just shared an article, Health Effects of High Concentration Cannabis Products. This is a review article in the American Journal of Public Health. So they just reviewed 450 studies about those kind of covering the space of THC concentration, duration, use. So again, I thought it was obviously topical both to recent speaker and obviously to our board's jurisdiction. I'm happy to get you a PDF if you can't get this PDF for whatever reason.
What page is the link for that on? Because I did not.
62.
62, yep.
Oh, there, okay, all right. And it's essentially the findings of the committee or whatever it was called, the meta-analysis.
Yes, this is like a review of like the literature on concentrates and effects of high concentration THC.
We should be able to access it because, or at least I don't know, on my Macintosh it came up very easily. But did anybody have any
able to as well.
problem? Everybody okay with that? Okay. Can't think of anything else. Motion to adjourn. Oh, by the way, there's going to be a new city council come Thursday. Not sure how that affects any of us, but Kristen, did you get a chance? I don't remember you mentioning what the process will be for filling the vacancy.
Sorry, Tom, are you talking about the lab vacancy?
Yeah.
So I believe there was some information provided in a previous packet. Kristen T can probably speak to that as far as the timeline goes. But essentially we will open up an application window. Any eligible applicants will go through an interview process, and then they're appointed by city council.
Yes, thank you, Kristen. We did make a brief discussion item of this at last month's meeting. There is not a separate recruitment for this vacancy due to the timing of the new recruitment cycle. So there will not be
that there was one or more applicants so far, and a relative. Maybe I thought when we had our planning meeting that there's a potential timeline.
And that potential timeline is the same one that licensing manager Changaris just provided. There's not going to be a separate recruitment for the vacancy. It will be folded into the same recruitment process when they open up for boards and commissions.
Okay.
Because there was just the November and December meetings. And then of course with the January. So I mean, they're folding it into the same, was their choice. We didn't have any applicants waiting in the wings, if that's what I thought I heard you say, something similar to.
I guess I thought I overheard something about at least one, if not more than one applicant, potentially. No?
We've had a couple of individuals reach out to us who are interested in applying, but they haven't actually had the opportunity to submit their applications yet.
Okay. Thanks. Okay, all right. Somebody want to make a motion to adjourn?
Brian motions to adjourn.
Second on that.
I'll second.
Any opposed or abstaining? Okay, well, thank you all and happy holidays and see you next year.
Thanks,
Happy
everyone.
holidays.
Thanks, staff.
Thanks,
Happy
everybody.
holidays. Thank you, staff.
And
Thanks,
thanks,
everybody.
Andy, and thanks everyone else too.
Thanks,
All
Andy.
Bye.
Thank you. Bye-bye.